Yes. First one she sent.
Right, jail, waiting rooms. Vice President, okay. All right, this is in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Dietos, and I have Jacqueline Weiss and Douglas Hartung appearing on behalf of the people. So this is a date and time set for two things, actually. One is a motion to withdraw a guilty plea that was filed with the court on June 21st. And I do have the response that was filed by the people. And then it's also the date and time scheduled for sentencing in this matter. Mr. Glazier, I presume you'd like to address the motion to withdraw the guilty plea first.
Your Honor, I've spoken with my client.
Can you stand at the podium?
It's hard for me, but I can't.
Okay, that's fine.
Your Honor, my client got a hold of me after the motion was filed, and he asked to withdraw the motion. And I want to make sure that this is something he's willing to.
Mr. Dietos, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you state your full name for me?
Christopher Nicholas Dietos.
All right, Mr. Glazier, do you wish to inquire with client?
Yes, sir. Mr. Dietos, we were in here and entered a plea on this charge. I forget the exact date. What date was the plea?
Looks like we pled on June 14th.
On June 14th. Do you remember being in court when that occurred?
Yes.
And I asked you a long series of questions. I think it probably took 10, 15, 20 minutes where we discussed your options, the plea offer that's been made to you. Some of those options included having our own independent evaluation and adjourning us out, getting that evaluation done and go from there. Did you, is that correct?
Yes.
And you understood that? You still understand?
Yes.
You understand that if we proceed with this motion and the judge grants the motion to withdraw, that we could still be able to do that. We would have a independent evaluation done. And if the judge didn't set aside your plea, we could always appeal that decision. You understand that?
What's that?
That means if we asked, we filed a motion to have this plea withdrawn, the prosecutor's objecting to it. And I don't know the reason. Well, I guess I know the reasons why, but I don't agree with their reason. But if we went through with the motion and the judge denied it, she sided with the prosecutor, said, no, you can't withdraw your plea. You understand we could appeal that decision, and the Court of Appeals could very likely allow you to withdraw your plea. You understand?
That means get it back.
I'm sorry, sir, you'll have to speak up.
That means get it back.
Take it back. That's right.
Yes, I understand.
And you don't want to do that.
I do want to take it back, yes.
Oh, excuse me. You do want to take the plea back.
Yes.
Okay. I'm just saying, you understand that if the judge denied your motion here today and we didn't withdraw it, that you could appeal that decision of her not granting you your motion. Okay? And you don't.
I can't hear him and neither can my court reporter, so we can't make, maybe you can sit, but Mr. Dietos, okay. Could you re-ask that question?
Yeah. You understand that if we proceeded with this motion, and let me ask the way I did originally, and the judge granted it, we could then do that independent evaluation and proceed from there, have a trial or whatever we could do from there. You understand that?
Yes.
Now, if the judge were to deny that motion and the prosecutor is objecting to it, you would have a right to appeal that decision by the judge. In other words, if she wouldn't let you satisfy your plea, you would still be able to appeal that decision. You understand that?
Yes.
And you don't wish to do either of those things at this time, is that correct?
Right, I would like to continue
I'm
with
sorry.
sentencing.
Wait, no, could you speak up?
Yes, I would like to continue with sentencing.
Okay. is there, let me ask you this, why did you make that, you made that request the same day that you took the plea? At least that's when your letter was dated to me. What caused you to file that letter to ask to have your plea set aside, you know?
I was underneath a lot of stress and I realized.
You gotta, all right, so
I
Mr.
really-
Dietos, why don't we do this? You go stand at the podium, because you're very soft spoken.
Okay.
So it's not, but Mr. Glazier, let him answer your questions.
Why did you send me that letter requesting that?
I was underneath a lot of stress and I didn't make the right decision after the fact. I knew I screwed up and I wanted to plead the whole entire time. I wasn't, just a whole bunch of stuff was going through my head.
Okay, were you getting advice from people in the jail?
They came right up to my door and started, and it got me overwhelmed, and that's when I made the wrong decision and sent, and that letter went through. And I didn't, and after the fact, I lost the opportunity to get the letter back, and that's where I'm at right now. But I do
When
want
I say people, we're not talking about,
multiple people, no.
not people that work at the jail, you're talking about inmates, other
Yes.
inmates, is that correct?
Yes,
And you feel comfortable withdrawing your motion to set aside this plea and proceed to sentencing today, is that correct?
that, yes,
I don't,
Okay, all right, so Mr. Dietos, you're asking that the motion to withdraw your guilty plea be withdrawn.
that means take it back, correct?
Well, okay, so you had asked your attorney to file a motion to withdraw the plea that you entered on June 14th, correct?
Yes, Your Honor.
Okay, so do you want to continue to sentencing today, or do you want him to argue the motion to withdraw the plea?
I want to continue with sentencing today.
So you don't want to take your plea back?
Yes, I do want to take my plea. Am I not understanding?
it's kind of tricky.
It's kind of tricky.
Yes.
So we have a motion to withdraw. You pled guilty the last time we were here to child abuse, first degree, and homicide manslaughter, correct?
Yes. Your Honor.
Okay. And then you asked Mr. Glazier to file a motion to withdraw your plea. Do you understand that?
Yes, Your Honor.
Do you want me to hear that motion today?
I would like to take the plea back.
Okay, okay. All right, so Mr. Glazier, are you ready to argue?
I don't think he's still not saying it right.
Your Honor, Mr. Dietos, you want to cancel the withdrawal motion?
What is,
You want to cancel the motion to withdraw your plea, right?
yes, I want to take my plea back. Basically.
You want
cancel-
to go forward with your plea,
Yes,
and you want to have the judge sentence you today based upon the plea to the charges of child abuse first degree and the manslaughter charge.
yes,
This is your voluntary decision to do this.
yes, no one else but my.
No one's coerced you or put you in duress to make this decision today.
No,
We're satisfied, Your Honor.
Do you have any questions, Ms. Weiss?
No, Your Honor.
Okay. So you want to be sentenced today?
yes,
Okay. All right, so,
Your Honor, may I? So when we set the sentencing date, the mother of Weston got ahold of me. It's today's her birthday, and she said she couldn't emotionally handle it and asked me to move the date. And I was under the impression that we were just having a motion hearing, so I didn't need the request to move it. And I didn't hear from Mr. Glazier that he was going to withdraw the motion. So I'm requesting to move this date to give the mother the opportunity to appear at sentencing. If we can even adjourn it by a week, Your Honor.
is there anything else?
No, Your Honor, thank you.
All right, so Mr. Glazier, I can move this to next week if you'd like, if you have any objection.
My client just wants to do it as quickly as possible.
I understand that, but victims do have a right to speak. And because the motion was on,
Can we do it tomorrow?
If I can get a hold of her.
Ms. Adams, could I see the book for tomorrow?
Sure.
Judge, my client thinks there was a victim's impact statement too.
That-
We never received a copy.
there was the paperwork that he showed me stated that there was a victim impact statement sent to Brittany.
All right, do we have a victim impact statement?
You know, I think it's just the one from the crime victims unit. I can show it. I don't think it got attached. It was supposed to. I'll show it to you. It's just the notice of the amount they were requesting. You want to see it, Judge?
No, you can show it to Mr. Glazier first.
I didn't get one.
So I can set this over till tomorrow.
This vehicle, that's all.
This is it.
It wasn't from,
It was
it just showed
the amount.
what they spent.
Do you want to, so I can set this for tomorrow and then Miss,
Your Honor, my mother, I can't hear her, but I'm assuming she said she can't show up tomorrow, but if,
okay,
I mean,
so I can do it another day, hold on. So I can do Tuesday.
next week.
I'm not gonna do it today, so
How far you go?
we are live on YouTube. I mean, I don't know, but I can't, by law, victims have a right to appear. And because there was a motion to withdraw, the people thought that's all we were doing today. So I can do it. I can do it August 2nd at 1:30.
Is that up there with you?
I don't know, Mr. Hartman just left. Is he checking on something or just leaving?
No, just left.
All right, what about August 2nd at 1:30? That, they're an hour and a half away, that gives them a little bit later to drive. Ms. Weiss?
Yes.
Okay, so we will,
Yes, the second from August at 1:30.
yep, so I'm gonna set this over to August 2nd at 1:30 PM. And the motion to withdraw plea is withdrawn. So we will see you back August 2nd at 1:30, and that'll be in person. We're stepping across, there it is. So we'll make sure to note that that's in person. Okay, anything else we need to address today?
No, thank you, Your Honor. I appreciate that.
Thank you both. All right, Rhonda Underwood, I got lots of jail. Hi, I have a gentleman in an Under Armour t-shirt. What's your name?
Harley Olmsted.
All right. This is in the matter of the people of the state of Michigan versus Harley Wayne Olmsted, file number 22-20693FH. Mr. Olmsted, we are here today on a contempt of court for failure to appear for a pretrial conference. You are represented on the underlying file by Matthew Murphy. The contempt of court states that you failed to appear for pretrial on March 8th of 2023 and haven't contacted us since. So, sir, do you understand the maximum penalty for contempt of court can be up to 93 days in jail? Gentlemen, do you want in the back? Mr. Noe, Mr. Keeney?
Would that be okay?
Well, yeah, I just gotta ask the bailiff. All right, so do you understand the maximum penalty can be up to 93 days in jail?
Yes, ma'am.
All right, so Mr. Hallowell or Mr. Olmsted, you do have a right to have a court appointed attorney for the contempt of court. Mr. Murphy is not here right now. but Miss Underwood is present. Would you like her to be appointed to represent you on the contempt of court?
Yes, ma'am.
All right, so Miss Underwood, I will appoint you to represent him. I'm assuming he's eligible since he already has a court-appointed attorney. And I am going to assign both of you to a breakout room. There you go. And hi, I'm somebody called in on a telephone.
We're Amanda
What is your-
Prophet. Amanda Prophet.
All right, Miss Prophet, are you in your car?
What was that?
Are you in your car?
No, Mercy had a storm last night. We've lost all power and internet, so I'm trying to use an app, but everybody's generators are running and I can't really hear.
Okay, all right, so what is your name again?
Amanda Prophet.
Okay, all right, so Miss Prophet, I'm going to change your screen name and then put you in the waiting room, okay?
All right, thank you.
Thank you. Miss Adams, did Demansky get adjourned?
I don't think so, but let me look in the ROA.
All right. Step off for a couple minutes, Jeff. You want to use the restroom again?
Hello.
All rise.
All right, Ms. Underwood, let me bring the jail back. You can be seated. Mr. Radley is not here, right? All right, so we are back on the record in the matter of the people of the state of Michigan versus Harley Olmsted. So, Ms. Underwood, have you had an opportunity to speak with Mr. Olmsted?
I have, Your Honor.
All right, and I'm going to presume you want me to enter a plea of not guilty, or instead of.
Yes, that would be correct, Your Honor. This is
All
Ms.
right.
This is Ms. Van Duzen's case, Your Honor.
Okay, so today is July 26th, so I'm going to set this over to, guilty, request for appointed attorney. I'm going to set this over to August 2nd at 8:30 in the morning. How's that with Ms. Van Duzen?
Thank you, Your Honor.
All right, your bond's continued, Mr. Olmsted, so we'll see you next Tuesday, all right?
Okay, Your Honor.
All right, thank you. You can go, you're all set. You're all set. All right, so let's see, we have those Hillwells. We're just waiting for Angelica Contreras. All right, everybody else is here for the next hearing, so we're okay. So Miss Underwood, last night I went to pick up pizzas at Aubrey's.
How was
And
that?
it was good. So I go in the side door and there's a guy sitting at the bar. And he looks at me and he goes, "Are the police still outside?" And I'm like, "What?" And he said, "Are the police still outside?" And I looked at him and I'm like, I don't know. And he's like, "Can you look?" So I did. I leaned out the door and I said, "Yes, the police are still outside." And he's like, "Did they follow you in?" And I'm like, "No, they didn't follow me in." And they said, "Do you have a warrant or something?" And he's like, no, I don't have a warrant. I'm like, "I can check if you want." And he's like, no. And there's a guy down the bar that knows my husband and he's dying laughing. And I'm like, "Well, you can always give me your name and I could, find out for you." And he wouldn't. Hi from the jail. So I think the last person I need is, oh, hi there, Miss Contreras.
Okay.
So anyway, I left and supposedly he finished his beer and didn't get arrested because I didn't see a name on the jail list for any arrest last night. So
Oh, good. Oh, good.
I thought that was pretty funny.
I had a weird, I walked in to a restaurant yesterday for lunch and I was just catching a bowl of soup. So I was just by myself, quick. And this woman, as she's going out, looks at me and goes, "I know you. You have a blessed day." And I'm not sure what way that was meant.
Well, I think that because of the pandemic, we started doing YouTube for cases and, so that victims could watch and, people weren't coming in the courtroom, and then we still do them for the criminal cases. So I think a lot of people watch them. And it's kind of like when we used to read the Telegram to see the new arrest sheet, to see what our friends are doing. But so they recognize us and they see us all the time, and then they think they know us. Because I had a woman the other day look in my card at Meyer.
Okay, we're getting Miss Contreras, right?
Yeah.
Okay.
So, she was like looking at what was in my cart and then talking to me, and I know I've never met her before, but she
Well,
knew me.
it's really kind of upsetting not to be able to go to Myers on a Saturday morning looking like a scrub anymore. You're like,
It's the only reason I like masks, because I can wear masks all the time and nobody knew who I was. I like when I go to Meijer at lunch to do my grocery shopping, people say, "Oh, you're not working today?" And I'm like, "No, it's 12:35. I'm at lunch. I am working today."
oh. Who doesn't try to get their Myering done at lunch?
I bet you don't even like going to Meijer or Walmart, do you? So, all right. Hopefully we'll get Miss Contreras.
All I will say is your poor cat. That's all I will say.
Yeah. He does get tormented. Mr. Radley is not in the courtroom, right?
I think he's coming by Zoom.
Well,
Sorry, Judge, I was on the phone with my boss. Do we not have are we not doing our sentencing?
which one?
Demansky?
Evidently, the attorneys adjourned that on their own to a date that I'm not even here for. So it's been adjourned to somewhere.
August
11th, then.
When did you put it, Miss Adams?
August 11th.
Yep,
Oh,
at 8:30. And then the only one we have left is the sentencing of Miss Contreras. All right, good morning, Miss Contreras.
No.
All right, so.
Your Honor, I will need a brief breakout with Ms. Contreras.
All right, this is in the matter of the people of the state of Michigan versus Angelica Maria Contreras, file number 22-21026FH. Ms. Underwood, I would note that on February 21st of 2023, I was provided a letter by Darren Coast that states Ms. Contreras has a show cause scheduled for February 24th of 23 for missing drug tests. I received word that she is using again. This is the second go around for not testing as directed. I would like to test her on the 24th if possible. She did not. So we have a failure to appear for sentencing and contempt hearing on March 10th, 23. So we have that contempt of court. And then I do have a PSI as well. So I don't see that. She requested court-appointed counsel for the contempt of court, but I do not see that she ever pled to the contempt of courts. She just
That's
asked
right,
for.
Your Honor.
So you would like breakout room, Ms.
Yeah.
Contreras? All right, so I'm going to assign jail number 1 and Ms. Underwood to breakout room. And then
Yours on the record, right?
I'm live, but I'm not on the record.
I was gonna ask, hey, Megan, this apparently Bradley is logged on yet. Can you give him a call? Or
I already did.
he's on. Okay, thank you, Megan.
You're welcome.
Okay, thank you.
All right, let me close that breakout room and bring them back. All right, Miss Underwood, so we are back on the record with Miss Contreras. Miss Underwood, how would you like to proceed today?
Ms. Contreras will enter a plea to the contempt, Your Honor.
Okay, so Miss Contreras, want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so Ms. Contreras, let's go through this. We have a contempt of court that was signed by this court on March 13th of 23, the warrant, and then it was filed July 10th of 23. And the contempt of court is that you failed to appear for sentencing and then a contempt hearing on March 10th of 2023. So let me go back. Find that other contempt. So the contempt of court that was scheduled for hearing on March 10th that you failed to appear for was that you failed to drug test on February 9th of 2023 and February 16th of 2023 at Lenawee Drug and Alcohol Monitoring as directed as a term of your bond conditions. So, okay, so another one. Another one. Hold on. No, original contempt. There's some Then I have a contempt for failure to appear for sentencing on December 16th of 22. So we have that one. And let's see, we have multiple contempt of courts down in district court too. Okay, so Miss,
Your Honor,
Ms.
she
Underwood?
resolved everything in district court.
Yeah, but
I know.
it's done.
no, I know she did. I just was mentioning the fact she had even more down in district court as well. So Ms. Contreras, do you understand the maximum penalty for contempt of court can be up to 93 days in jail?
Yes, Your Honor.
Okay, and you would ask for court-appointed counsel. We appointed Ms. Underwood to represent you on the contempt of courts. Or did you want Ms. Underwood to represent you on the contempt of courts for these matters, ma'am?
Well, I thought I'm just pleading guilty today to the whole thing, so.
Right, and so I guess I was just asking, Dawn Van Dusen was your attorney on the underlying matters, and Ms. Underwood is court appointed on the contempt of courts. So are you satisfied with Ms. Underwood as your attorney on the contempt of courts?
Yes, ma'am.
Okay, and Ms. Underwood, were you going to want to proceed to sentencing today or no on the?
Yes, I believe so, Your Honor. Ms. Van Dusen asked me to cover for her on this one.
Okay,
Ms. I believe she's very aware of the recommendation, and Ms. Contreras as well. And Ms. Contreras has done 30 days, I believe, already. So I believe we're ready to proceed to sentencing.
okay. Don't show that there was any cops or anything. All right, so Ms. Contreras, Ms. Van Dusen represented you on the underlying file. Ms. Underwood represented you today on the contempt of courts, and then are you okay with proceeding with her to sentencing on everything today?
Yes, Your Honor.
So you're gonna plead guilty to the contempts, and then we'll proceed to sentencing on everything.
Yep, yes, ma'am.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
And as I explained to you, the maximum penalty if you plead guilty to contempt of court or are found guilty of contempt of court could be up to 93 days in jail. Do you understand that?
Yes, Your Honor.
All right. Now, do you understand you have a right to contest the contempt of court charge and to have a hearing on it?
Yes, Your Honor.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
Do you understand you have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial? Do you understand all of that?
Yes, Your Honor.
You do not have to testify at your trial. No one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, Your Honor.
All right. So on the contempt of court, how do you plead to the charge that you failed to appear for sentencing and a contempt of court hearing on March 10th of 2023?
Guilty, Your Honor.
And how do you plead to the contempt of court that you failed the drug test on February 9th of 2023 and February 16th of 2023 at Lenawee Drug and Alcohol Monitoring as directed?
Guilty, Your Honor.
Okay, and let's see here. Guilty to the contempt. All right. So the other prior contempts you already pled guilty to. All right. So do you understand that by pleading guilty, you'll be giving up your right to a trial as I've already explained to you?
Yes, Your Honor.
Has anything been promised you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
If I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes.
All right, so Ms. Contreras, you were required to appear for sentencing and contempt on March 10th of 2023 in this court. Is that correct?
Yes, Your Honor.
And did you show up that day?
No.
Were you in jail?
No, I don't think so.
Okay, and were you hospitalized?
No.
You just chose not to show up that day.
Well, actually, no, when I was working out in Jackson and then I got stuck out there and I had to work until I made it home, like was able to take a bus home because yeah, my vehicle broke down there and that was about it. And then I did drug test like once or twice for daring costs, and then I couldn't afford it anymore because I had to recollect all my credentials. Like I finally got a new birth certificate, a new social security card, and an ID.
All right. Now, you were also ordered to drug test on February 9th and February 16th here in Runaway. Is that correct? You tested for daring costs.
I was on colors, so I had to call every day. So, and then I went through multiple phones. I've been through like 3 different phones, I think. So.
All right. Would you agree you didn't test as required on that time period?
No, Your Honor.
Okay. All right. I accept the plea. It has been given. Understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. When did you get, how long have you been in jail now? Like over 30 days?
Just about, yes.
Okay. All right, so Ms. Contreras, you're also scheduled for sentencing on your felony case. Have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Have you had an opportunity to discuss the pre-sentence report with Ms. Underwood, your attorney?
Yes, Your Honor.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
The probation department has computed the minimum sentencing guidelines to be 0 to 9 months. Do you agree with that computation of guidelines?
We would.
In determining, or I'm sorry, before the court passes a sentence, is there anything you'd like to say on the underlying file as well as the contempt of courts on behalf of Ms. Contreras?
Your Honor, Ms. Contreras, I think, as she stated, got caught in a situation where, she's in Jackson and doesn't have money and the car breaks down. And that happens, but she would not excuse that behavior at all, Your Honor. Ms. Contreras understands that she's had 30 days to think about it. She understands that she has to complete this probation and she has to complete probation downstairs, Your Honor. She understands that she's going to be required to do certain things, and we would hope the probations would work with each other so that she's not double doing different things. But we would ask the court, Ms. Contreras is employable. Where did you say you were working, Ms. Contreras?
I'll be working at Kirchhoff when I get out of here, like a for sure thing.
And so we would hope that the recommendation would be implemented by the court, that the contempt Ms. Contreras would be sentenced to time served, and that Ms. Contreras can get out and get a job and complete her probations, Your Honor. Thank you.
Ms. Contreras, anything you want to say on your own behalf?
I'm ready, Your Honor. I have a lot to do, like district, and I was really trying last time. I just was drowning because I was waiting on my ID and all my credentials and was having a drug test for upstairs, downstairs, and I had multiple court dates, and so I kept missing other ones, but I was reporting every month, and yeah, I was doing what I was supposed to be doing, so.
Miss Walsh, I do show she was probably arrested on probably July 9th to today.
I
Would that
don't,
credit?
I don't know, was she arrested on the contempt?
of court.
Okay, then that does
Yeah.
not count towards the credit for me. It's a
Okay.
separate thing, but she does have, I think it's 96 days on our case, my case.
Okay. All right, so. So she's got 14. 22, 23. I show an additional 24 days for the contempt if she was arrested on. I'm assuming she got arrested on July 9th.
You're talking to me?
No, I don't know, Miss Underwood. Okay, all right, so in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication from law, and the protection of society. It's a sentence of the court, Ms. Contreras, that you will be placed on probation for a period of 18 months with the Michigan Department of Corrections. You are not to use any alcoholic beverages or other intoxicants. You must comply without testing, not to use any illegal controlled substances or paraphernalia, and comply with testing. Only use prescription drugs as prescribed by your licensed physician. You must enter in complete outpatient substance abuse treatment. So I'm going to order that from the start, Ms. Walsh, because I think she needs it.
Okay.
You must complete your GED or adult education program, obey all court orders, not to engage in.
I have my diploma.
Well, you gotta file, you gotta bring proof of that to Ms. Walsh.
Yep.
No contact with anybody with a felony record. Can't move unless you get permission from Ms. Walsh, not to use any object as a weapon. You're gonna get out of jail today, so Ms. Walsh, when do you want her to report to you?
Monday morning before 11 a.m.
Okay.
That's the third floor of the courthouse.
Judge, I do also want to just put on the record, the drug testing is $20 per drug test, and it will be at the same place you were testing. So it'll be random.
But I do have a job though this time. I have one here in Adrian, so.
So, will that be colors? Is that how you do that, Ms. Walsh?
It is, yes.
Okay.
Did you say you have a job in Adrian?
No, well, it's in
It's Tecumseh.
Rogers. Yeah, it's off. So it's Tecumseh.
Okay, you must submit to search and seizure of your person and property if the agent feels that they have reasonable cause to believe you have violated the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence within 24 hours to the probation department. You must maintain employment of a minimum of 30 hours per week. You must surrender all tax refunds to pay off your fines and costs, and you must comply with DNA testing and pay a $60 fee. She did get tested, so we just need a $60 fee. And then there is a crime victim assessment fee in the amount of $130. There's a $30 per month supervision fee without tether, $60 with tether, $750 in court costs, paid at a rate of $50 per month. Attorney fees in the amount of $450, paid at the rate of $30 per month. Let's see, crime victim assessment, $68 state costs. So I think I got it all. Anything else to add? Ms. Walsh, I'm going to give her a credit for time served on the violation of probation or on the contempt of court. And you didn't recommend any further jail time on the underlying file. So on the underlying file, you have credit of 96 days. But I'll give you credit on the contempt court. So you get credit for time served on all the contempt courts, all right?
Okay, yes, Your Honor.
All right, so you're gonna get out of jail, and I know that you have a substance abuse issue, but you will be tested Monday morning.
Well,
So
well, as soon as I'm released, I still have to go and report to district, because I already did their recommendation of 15 days and.
Yeah, I don't care about district
Okay.
court. I'm telling you, you're gonna get released, and I know you have substance abuse issues. I don't care if you have to find an NA group and go there every day, but you better not test positive on Monday, all right?
Okay, yes, Your Honor.
Anything else, Ms. Walsh?
So I have already sent an email to the testing facility that you are going to go there as soon as you're released from jail. So that's expected to be today to check in
Okay.
to get your stuff set up there.
Okay, yes, ma'am.
She doesn't have to test today though, right?
No, I don't know,
Okay,
but
so just know that Monday you will. I just want to make sure you're not using over the weekend, all right?
Yes, Your Honor.
I do have the right to appeal this sentence. And they're gonna give you at the jail 3 copies of your notice of right to appellate review. They're gonna ask you to initial and date 1 copy for our records. The other copies are for your records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Yes, Your Honor. Thank you.
All right. Thank you.
Yeah.
Thank you, Your Honor.
Ms. Underwood. Do you want to get Charles? No, for Charles.
All right, ma'am.
Is that what
Your Honor.